safety exception, we support that. Whatever else you can say about such exceptions, they are very common in Western water law. Based on a quick survey of states, I count maybe half a dozen that have us expressly in the water code, have things very much like the board's rule. The rest mostly by policy. And these are managed to be administered all the time. And the most recent example being the Klamath River last year, the curtailments, there was an exception such as that, and it was uncontroversial. The section dealing with voluntary alternative arrangements is an alternative to curtailment we strongly support as well. Based on our work in the state, we know that the best source of knowledge of complex hydrology is often local, and whatever can encourage stakeholders to get together and come up with better options than a one-size-fits-all, we think it's important to incentivize that. At the same time, I think the rule rationally puts the onus on stakeholders to take the initiative and come together and develop these proposals, and in light of the urgency of the situation, I think it's reasonable to do that. Finally, I just want to say a couple quick words about due process, and I won't purport to be an expert in this area, but I have enough background in criminal law to know, as staff pointed out, the due process is a flexible inquiry. It involves a balance of harms, and the law recognizes that. And when harms are unfolding rapidly, and there's a balance to different parties experience harms, the law says the amount of due process that has to be given by the government varies depending on the situation. In the context of a drought, it's not like if we wait. We've heard a lot of calls to wait and take our time and get this right and be patient. And I just want to point out that it's not as though if we wait and take time to work this out that harms aren't going to occur. It's just they're not going to fall on the party that would have been curtailed. They're going to fall on someone else, another water user, another rights holder, or public trust resources. And I think it's really important to bear that in mind. So in conclusion, I'll just say that we certainly don't envy the board's task of having to administer water rights in this situation, but we certainly appreciate the board's initiative and the approach they're taking to do that, and we support the rule. Thanks very much.
Thank you, Mr. Clifford. Next, Barry Hill, U.S. Forest Service, followed by Dustin Cooper for miscellaneous water rights holders.
Thank you, Chair Marcus and board members, for this opportunity. My name is Barry Hill. I'm representing the USDA Forest Service Pacific Southwest region. Our concern with any approach to curtailment is that it should have a health and safety exemption in it. There's two main purposes for which we feel this is necessary on the National Forest System. First of all, for firefighting purposes. As of yesterday, we had a total of 245 post-1914 appropriative rights which had received curtailment notices for sources which are used by the National Forest System for firefighting. We feel that we need to be able to rely on these sources in this challenging fire year. Secondly, as Mr. Thomas mentioned, there are a large number of recreational residences on National Forest System lands. In many cases, the water rights are held by the National Forest themselves, and we believe there's a total of over 1,000 recreation residences that are in the situation of being curtailed currently through their water rights held by the National Forest System. So in summary, we feel it's very important to include the health and safety exemption and ask for your consideration. Thank you.
Thank you. Dustin Cooper, followed by Paul Manazian from the Exchange Contractors.
Good afternoon, Dustin Cooper. I'm an attorney with the Manazian Law Firm. Our firm represents a lot of water right holders throughout the state, many of which signed on to a letter that was lodged for your consideration. Rather than going through the points of that letter, some of which has already been discussed, I want to focus on an issue that has not been raised at all. And that is, what is the process for unraveling the curtailments in the fall or hopefully before that? Mm-hmm. This is a significant issue to everybody that's curtailed, whether it's a post-14 or possibly some pre-14 or riparian. On June 17th, 3 of our districts that are located in the foothills that also operate reservoirs submitted a letter raising this issue and asking that the board publicize what it intends to do and hold a workshop on this significant issue. They're probably the most potentially harmed by a failure to address this issue and a failure to proactively come up with some kind of process where they can kind of anticipate, okay, it looks like the curtailments are going to come off.
Right, right.
They do not have adequate groundwater supplies. And as I mentioned, they're located in the foothills, which it can be somewhat of a flashy system. So if one of the 3 districts receives an isolated storm, that benefits them greatly, but it doesn't benefit the entire Bay Delta watershed.
Right.
Do they get to retrieve that water?
Question.
So the 3 districts that I'm speaking on behalf of are Paradise Irrigation District, Nevada Irrigation District, and South Feather Water and Power Agency. And again, last point, I can't, the importance of this issue it cannot be overstated. If they are unable to capture fall precipitation, and we have a year like we did in 2012 where we had a very wet October, November into December, and then a dry 2013, if they can't capture that and we have a dry 2015, then they will have dramatic water supply crises in those districts.
Right.
So, thank you.
Thank you. Can you all address that? I believe your intention was to post lifting curtailments ASAP, but he raises the point about the scope or the scale of lifting curtailments, say when you're in a small part of a larger watershed.
This is something that's on the expanding list of things that we think we'd like to augment. We want to add the words "and suspend" so that we consider within the regulations that we would not just initiate the curtailment, but suspend curtailment, and using the same process of the information that we'd be making available that shows the time that we'd be suspending it.
Right. So that's, okay. That's when we have to.
And we can point to recent suspension of curtailments last week in the case of the Deer Creek
Well, that's, I
curtailment.
mean, that's an example, I mean, of 2 things where we've have a regulation and we didn't necessarily even invoke the regulation and issue curtailments, but also that we suspended curtailments when appropriate to do so based on the information.
Great. Mr. Manassian, thank you very
Paul
much.
Manassian for the
Manassian,
17
sorry.
River Exchange Contract.
Followed by Alan Lilly, just so that the next person knows.
Remember that you are viewed by us as a judicial body required to represent and recognize rights. We know that you want to do something, all right? You're action folk. I understand that. But do not, please, put this august body in the position of being both the policeman, the finer, the terrorizer, and then the judge upon reconsideration a couple of years hence. I know that there's some emotion about the situation in the Delta, and that it appeals to you that perhaps the facts show that people are using water knowingly in excess of what is available to them. First of all, it isn't a bunch of scofflaws in the Delta. It's people that thought they were going to get a contract from the Bureau and the State Water Project when those projects were developed, and the contract either never arrived or the terms and conditions demanded of them did not fit, in terms that there were no guarantees of quality and there were requirements of payment which they felt were inappropriate in light of the fact that those people were maintaining the levees for this canal system across the Delta. So get the scofflaw business out of your mind. What you want is people to act rationally when it's short of water. And rational people would curtail their plantings. They wouldn't replant a crop in August. They would not irrigate the alfalfa after August 15. You can accomplish all of that by simply noticing a hearing to go through the hydrology. You know, we had a hydrology hearing today, didn't we? It was kind of sketchy, on and off. But let's put your staff to the task. Let's put the projects to the task, and let's test this out in 8 hours of hearing. And then if you decide that, in fact, you can pin the amount of water available to the riparians, is it 80% on August 15? Is it 70% on August 30? You tell us. I'll bet you if you put that in the newspaper with a paid ad, you will see people start to curtail their use voluntarily, because the terror of these charges, you do not realize what you are doing. Prudential, Metropolitan, they're not going to lend money on people that are threatened with 3 or 4 acre feet of overuse. That's more than the land is worth in many cases. So you're creating an image of a body that today is of an august, quasi-judicial nature, and you're about to embark on something that is not factually justified. It's not going to get the reductions in plantings that you want from notice, and it's not going to test out these hydrologic theories.
I have a question, wanting to understand if this is the same idea that Mr. O'Loughlin presented or something different, because he's saying misappropriation, illegal diversion, and you're saying notice a hearing on hydrology.
I'm not
I just want to
quite
make sure I
as-
understand the process that
Yeah,
you're suggesting.
the process is exactly the same, which is how much natural flow is available for particular classes of water rights holders to use. And Mr. O'Loughlin made a very telling differentiation between taking someone's water and basically sometimes parties that are transporting water mix their water with the water that is available to other people, or they delay it in such a fashion that you cannot simply look at the amount of storage that is going down and saying somebody's stealing my water. So it's slightly different. I think I would go through the hearing, hydrology hearing. You, at the end of it, you can go off in 2 directions. You don't need these regulations to be adopted today or tomorrow in order to terrorize everybody. The legislature's done that. It's $2,500 an acre foot, $1,000 a day. In a matter of 3 or 4 days, that basically puts most agricultural acreage underwater. Now, how are you going to sell or finance an agricultural operation in the Delta? You've already done it. The only question is, are you going to document that you intend to carry forward that terror program? And so I think Mr. O'Loughlin and I believe, are talking about exactly the same sort of hearing. Factual hearing in which your staff puts up its ideas, and the public, if the Delta folks are who you want to target, fine, but I agree with San Francisco and Modesto. Why do the rest of us who have planned for these drought situations and done what we can, sometimes we've been very fortunate, but the bottom line, why do the rest of us need to be netted into your reign of terror? I know you don't intend it that way, but that's the position your staff is putting you in because you're so anxious to do something, and you're kind of inferring they're not doing anything about this problem. Well, I mean, we've been developing water for a long time in California. We haven't done really that bad a job if we can withstand 3 years of drought, have we? Do you really want to throw that all up? We want you to be the centerpiece, provide the opportunity to test these hydrologic theories. And I believe you will conclude that some of the people in the Delta either don't have the water rights or are using too much in August. That's very possible. I think if you would inform them of that, they would plant less tomatoes next year, and they'd leave the bottom end of the alfalfa field out if it's dry. That would be a major accomplishment. Or they'd go get the contract that has been promised by the projects and never quite arrived.
Thank you. Alan Lilly for Yuba County Water Agency, followed by Dino DiCarlo for DiCarlo Farms.
Good afternoon, Chair Marcus and members of the board. My name is Alan Lilly, and I represent the Yuba County Water Agency. And I'm going to just summarize a couple of points today because these things have been covered fairly well. First of all, the papers in the state board's staff's agenda item repeatedly refer to protecting senior water rights. And yet no senior water right holder has come forth today and asked for protection. And that is very, very significant. And frankly, the staff, I mean, we've met with staff several times and we appreciate their meeting with us, but we keep asking, who are the senior water rights who are going to be protected? And we never get any answer other than, well, there are senior water right holders out there. And I think Mr. O'Loughlin really hit the nail on the head here. This is really an issue of protecting or preventing unauthorized rediversions of project water that have been released from Oroville and Shasta and Folsom. And it should be addressed as such and not as a water right curtailment matter. Now, the second point and last point I want to make is if the state board does go forward with the proposed regulation, again, building on what Mr. Cooper said a few minutes ago, you really do need to figure out how this is going to stop. And I think there's a very simple way to have it stop, and that is to have it say it stops on September 30th. And I point to Appendix 9 from the agenda package, which has the supply and demand curves, and they all go through September, and they don't go past September. And we all know demands go way down. Obviously, there's not the irrigation demand. We know supplies go up. There's not as much evapotranspiration of the riparian vegetation, and hopefully there'll be some precipitation coming. The problem that, and we all know that the reservoirs are in desperate need to be refilled, all the reservoirs in the state. Now, staff may say, well, don't worry, we'll be on it and we'll curtail when we need to. But, I mean, we've been around this process before. What if we have a storm that comes on a Friday night and it's over by Monday morning and there was no one we could call? Can we divert that water or not? I mean, this is not idle threat. This is likely to happen. And we may not get very many storms during the next water year. As I say, even if the state board goes forward with some kind of regulation, we highly recommend and request that you have a fixed termination date, and we think September 30th is appropriate. This can readily be addressed in paragraph 15 of your proposed resolution on page 3, which right now says it'll remain in effect for 270 days. There's nothing in the law that requires it to do that. And that could just say through September 30th. And then on page 4 in the order, paragraph 4 says these regulations will remain in effect for 270 days. And again, that can just be changed to September 30th. We can still look at curtailments if necessary after that, but it's going to be a whole different hydrology than the summer hydrology. And I'll be glad to answer any questions.
Thank you. Thanks. All right, Dino Del Carlo, followed by Richard Roos Collins for American Rivers.
Hi, good afternoon.
Hi.
My name is Dino Del Carlo. I'm a fourth-generation farmer on Roberts Island in the Central and South Delta. We farm processing tomatoes, processing cucumbers, asparagus, alfalfa, olive trees, and a few almond trees. We currently have about a third of our acreage under drip irrigation. So, and most of the people in the Delta are following suit with that. We're a little bit behind the curve, but there's more and more going in every year. Myself and our neighbors have already fallowed some land. We haven't planted crops behind our wheat harvest as we normally do, being that we know that there's not the water in the system that there normally is. But the problem I have with this whole process is the timing of these curtailments. The previous gentleman talked about living in terror. My life has been a terror for the last month. Not sleeping at night, not being able to be nice to my children because I'm constantly worried about what's going to happen. Our family farm, which it is a family farm, we have probably, I figure, $4 to $5 million invested in our crops already at this time. If I'm not allowed to finish growing those crops, I'm basically going to go bankrupt after 4 generations, and that is not okay. So I'm asking you to please look at other options. Let us finish our crop this year, and let's plan better for 2015. Thank you.
Thank you. Richard Roos Collins from American Rivers, followed by Rudy Musi.
Madam Chair, members of the board, American Rivers supports your adopting an emergency drought regulation, subject to some amendments and some due diligence. First, what we support, you plainly have the authority to regulate pre-14 and riparian rights to prevent waste and unreasonable use and to protect the public trust, as recognized by Racanelli in 1986, Roby in 2006, Light in 2014, and other cases. Second, this rule is intended to protect priority of right that is essential. Third, the rule recognizes the importance of cooperative arrangements, and we support that too. As to amendments, we support the amendment proposed by Mr. O'Loughlin and the SJTA that an order must contain the specific basis for the order. And we also recommend that you follow the lead proposed by Mr. Knapp for the City of San Francisco to clarify that any order is not a final determination of priority or any other term of water right. If it is final, then litigation is not only certain, it will be monumental. Now let me go to due diligence. I believe you view this as a complement to the authorities that you already have, not a replacement. And if so, the question is, how will this work? And so let me list some questions that have occurred to me in the course of this hearing and recommend that staff address them before this rule is either adopted or implemented. So first, do staff intend to issue curtailment orders to all post-14 rights before turning to any senior rights? Second, based on what we know so far, how many senior rights will be subject to curtailment orders? Third, given what we know based on statements of use, how many of the senior rights do we actually know the priority dates? I mean, of the 15,000. Next, what procedures would the board follow in connection with a petition for reconsideration? In other words, how would you prepare for such a hearing? How quick would such hearings be scheduled? What's your capacity to hold them? There might be 50, there might be 500, there might be 5,000, depending upon how far you go. What is the capacity to hold those hearings? Will penalties accrue during the time that the petitioner is requesting a hearing? How will you track water which is released pursuant to a curtailment order? And what's the relationship between this and other mechanisms? Now, I ask these questions not to damn this proposal with faint praise. As I said, American Rivers supports this proposal in general. But it seems to me that this board needs to understand how this will work before you put it to work. And while I understand that staff had limited time to present answers to these questions, which certainly occur to them, it seems to me that you need the answers before this is implemented. Thank you.
Question.
Go ahead.
What do you think of the suggestion by Mr. O'Loughlin and Mr. Manassian? That is that we utilize a different approach, have a hearing on hydrology in the Delta.
I think it's an excellent suggestion. I don't view it, Ms. Diadamo, as a substitute. I view it as something that should occur regardless. And the sooner the better.
Mm-hmm.
So perhaps one of those intermediary steps.
Perhaps. Or.
Thank
Thank
you.
you very much.
Yeah,
I'm sorry, Mr. Ruiz-Collins, before you leave, if you mentioned it, I missed it. Did you have a thought with respect to the public health and safety provision?
Ms. Dodek, I have not thought that through, so I don't have an answer today. Thank you for asking.
Yeah, before you leave, when we talk about the basis, for issuance of a curtailment order, and we've talked about, we have that and somewhat stated in the proposed regulation, the available demand, available supply, all of the information on priority and dates. Do you think it's helpful if we also included as a statement of basis complaints received, in terms of having some kind of a trigger that's more locally based and kind of less of a top-down trigger, but more of a bottom-up trigger for initiating a curtailment? you know, not just writing a letter and sending it in the mail, but initiating dialogue with the participants in the watershed. So as a statement of basis, do you think complaints received, for instance, is something we should call out?
Mr. Moore, I believe that will be helpful as an indicator of relative seniority in a circumstance where we really aren't certain about priority dates. And so just to take the hypothetical that's been in my mind, you issue the first curtailment order to a pre-14 right, its defense will almost certainly be that its priority date is different than you think, or that others who have not yet received the orders are lower, have different priority dates. And so a complaint might be useful to help sort through that sort of thing. But bottom line, it seems to me that this board, if you issue curtailment orders against pre-14 or riparian rights, you must have mechanisms in place to understand priority dates and to resolve the disputes that will inevitably arise about those dates. Thank you.
That's what we're here for. That's true. Mr. Musi, thank you, followed by Diego Olagare. I hope I have that right.
Hello, and thank you. My name's Rudy Musi. I'm a farmer in the Central Delta, South Delta. My family's farmed there approximately 80 years, and in those 80 years, we've never faced a curtailment. The proposal that you're seeking to enact would definitely bankrupt my family. I'd also like to focus on some legislation that the focus seemed to be focused on the Delta as being the bad person. But in 1931, the County of Origin law was passed. In 1933, I'm sorry, the Watershed Protection Statute was passed. In 1959, when the CVA project was adopted, it also adopted in the same legislation the Delta Protection Act. Also in 1984, the Area of Origin was adopted. And I'm going to quote from Craig Wilson, the Delta Water Master, and I think he delivered this in front of this board. The common purpose of the law was to assure the areas where the water originates that they would have adequate water supply for present and future needs. They were not intended to preclude export of water to other areas before those needs arise, but instead the needs of the area of origin would take priority if and when they arose. Thank you.
Thank you very much. Mr. Olagare, you'll have to tell me how to pronounce it. I'm so sorry. And then Brett Warner after.
Good afternoon, Madam Chairman and board members. My name is Diego Olagare. I'm a farmer from the Lodi area, and we farm also in the Delta region as well. We farm wine grapes as well as alfalfa and then some row crops. One of the things we realized as the previous speaker spoke of, our area has really changed. At one time it used to be mainly corn, wheat, and asparagus, and over the years it's evolved into more permanent plantings such as grapes, olives, blueberries, walnuts. And with those permanent plantings, we can't tolerate any brackish water. And we are, once they're planted, regardless if it's a drought year or it's a wet year, we still got to keep those plants alive. And the problem in the Delta is we all rely on diversion out of the river system, and there's no wells to speak of because of brackish water. So we're solely dependent on river system. We can't go out there and drill a well if we have a curtailment. It just doesn't work. And we put salt water in our plants, it's going to kill them over a period of a year or two. So that's what we're up against. We've made a considerable amount of investment as far as conservation practices. Most of us have put in some of the state-of-the-art irrigation systems that reduce considerable amount of water usage, as well as runoff, as well as having critical timing of fertilization and some chemical applications. We've also implemented sustainable practices to where we cut down in dust, we cut down in insect, and practice integrated pest management. So we're trying to do everything we can to make the environment better, as I say. One thing that really hasn't been fully addressed here is the full economic impact from loss of agriculture in the Delta, especially as it relates to these permanent crops. They're high investment crops. We employ a lot of hand labor when it comes to grapes and blueberries. And there is an indirect economic impact with all the processors involved, the trucking companies involved, the fertilizer companies involved and such. So that's something that hasn't really been fully addressed throughout the day. And finally, what I want to mention is it's common sense. I mean, it's common sense this water's commingled. It's common sense there's water in the river that flows by us. We as landowners diligently fight floodwaters during those wet winters, sandbagging out there. We maintain those levees. We pay taxes on those levees, as well as half the river. It seems like it's common sense that some of that water should be ours. Even during these difficult times, I think we all should work together and share on this. Thank you. Any questions?
No, thank you very much. I'm sorry for mispronouncing your name. It's great. Brett Warner, followed by Peter Rietkirk.
Hi, I'm Brett Warner. I'm a Walnut. Excuse me. This is my grandson, Jonathan. This board is, I think, going to take away his future. I'm a walnut farmer. I'm in the TID irrigation district, and we have riparian water rights. Walnuts are a 35-year investment. 1 year without water, that investment is gone. I've spent my whole life building this, and one notice come in and we're done. In the past 40 years, the population has doubled in California. Of that, Jerry Brown's been governor 12 years. He's done nothing about water storage. I haven't heard a word about water storage here. It's the only answer. I think this is basically theft of senior water rights, not the other way around, the way I'm hearing it anyway. I have other things written down, but that's it. Thank you.
Thank you, sir. The intention is to protect senior water rights, just so you know, but I can understand the confusion, and we're going to talk about that a little bit before we close. Mr. Rietkirk, followed by Jeannie Zalesi. Jean Zalesi. Jeannie?
Chair Marcus, members of the board, thank you for the opportunity to provide public comment. My name is Peter Rietkirk. I am the General Manager of Patterson Irrigation District. Patterson ID is a pre-1914 water rights holder on the San Joaquin River. PID is comprised of over 680 landowners on 13,500 acres in Patterson. The growers of the district are truly small family farmers, as the average field size is just over 20 acres. The Patterson area was developed in the early 1900s around a colony concept. Settlers would come to the area, purchasing small plots in which to support their families through development of various and diverse agricultural interests. That concept is continued to today. Today, family farms grow a variety of crops, including alfalfa, corn, wheat, oats, beans, tomatoes, melons, and in addition, the district now is comprised of over 30% permanent crops, including almonds, walnuts, apricots, and cherries. All in all, our area generates approximately $38 million in economic activity annually. Many landowners came to the Patterson area because of the reliability of water rights available to their lands through vested pre-14 water rights. Many of these growers could have farmed elsewhere, but the water rights attached to the area provided them the stability they needed to endure the many other variables that life can throw at them. These water rights have allowed them to provide a meaningful contribution to California's robust agricultural economy through job and product creation. It's allowed them to support their own families and allowed them to build a legacy they hope that will someday be passed on to future generations, much like the prior grower just represented. I know I'm speaking of Patterson area only, but I also know that my area is a microcosm that is representative of many senior water rights holders on the San Joaquin River and the Sacramento and in the Delta. What you're doing by enacting emergency regulations is to fundamentally change the water rights foundations that our family farmers, agricultural institutions, and related industries have built their legacies on. PID does not support the adoption of emergency regulations. The emergency regulations as written appear innocuous, but without transparency of intent, without discussion and justification of the process for curtailments, and without due process, one can only assume that the efficiency of expediting the curtailments through proposed regulations will ultimately trample senior water rights holders. The regulations are not necessary. The governor, through the emergency drought proclamation, had already increased the fines afforded to staff members of the board, or of the Water Resource Control Board, to enforce the curtailments. I thought Dee Dee brought up a couple of very good hypothetical questions today with the intention of clarifying those comments, and it was very clear that the dollar fines associated between the current authorities afforded to them and the regulation were were only $500 a day, with the ability to continue and provide the $2,500 an acre foot fines that are currently there, which are huge and will quickly bankrupt districts and growers. We agree that flows in the San Joaquin River are incredibly low. Water rights holders are working together in an attempt to maximize the availability to all parties in the system and provide minimal but meaningful water supplies as life support to agricultural food chains in the state. Growers have cut acreage and employed deficit irrigation in an attempt to reduce water usage and spread available supplies around. In PID, this is being done voluntarily with the understanding that this will negatively impact yields for this year and in future years. In my district, this has resulted in a 32% reduction in consumptive use this year. This cooperative spirit is the spirit that the state board's promoting, and that cooperation will be cut short when pre-1914 water rights holders are forced to protect themselves and their rights from legal infringement. The emergency regulations will result in litigation against the state board, and this will further divert public resources that are intended to efficiently administer California water rights during this historic drought period. In closing, the curtailments in the San Joaquin River watershed to solve a water shortage problem will create a larger problem that transcends the original curtailment issue. Pre-1914 curtailment actions through emergency regulation will promote distrust and discord during a time when the state is attempting to make meaningful strides in water policy. I implore the state board to consider the weight of these actions to enforce the existing through existing authority post-14 curtailments and not adopt the emergency regulations before you today. Thank you.
Thank you. And just to be clear, you're saying even for post-14s, use traditional rather than the emergency regs as a senior water rights holder?
I believe that the state board has the has the authority to do so currently. I think they need to do their due diligence, though, to make sure that post-14 water rights holders are appropriately curtailed before attempting to curtail more senior water rights holders.
Ms. Alesi, followed by Dean Rees.
Good afternoon, board members, and thank you. My name is Jeannie Zalesi, and I represent Banna-Carbona, Patterson, West Stanislaus, and the West Side irrigation districts. I want to really hit on two things. I've toned it way down because a lot of things have been covered, but they really focus on process. I really wanted to focus on our concerns with the information that you're dealing with, but it sounds like, at least coming from your staff and coming from your statements, that you understand the difficulty with getting the information correct, that you understand the shortcomings of the information you're working with. There are 3 things we think you need to look at. We discussed flow already this morning. I think you see that clearly. I think the demand needs to be dealt with as well. Relying on 2010 does not always work. As Mr. Riekert just said, Patterson Irrigation District alone has reduced its demand this year by over 30%, and the rest of my districts have done the same. Demand really needs to be looked at. The third thing I haven't heard mentioned is hydraulic continuity. It's important to know that before you curtail a water right holder for a more senior downstream water right holder, you have to be able to show that that water would get there, that the water, if it's not diverted, will be able to get to the other senior water right holder. Otherwise, you can't impose a curtailment. So all those things I think you understand. I think your staff understands from what's been said this morning. What really concerns us is the disconnect. There appears to be a very serious disconnect between what you're saying and what your regulation says. And I would urge you to read it, because it provides no protection. It provides no direction to your deputy director whatsoever. Those good intentions don't mean anything if they don't show up in your regulation, because there is no, I mean, with all due respect, there is no trust there. I think you can sense that in this room today. So if we're going to trust that what your staff is saying is going to happen, it needs to be in the document that you adopt. For the same reason, we heard statements this morning that even if this is adopted, you may not curtail pre-1914 water right holders immediately. It may be sometime in the future. With all due respect, again, if you adopt this emergency regulation today, that's not your decision. You have completely delegated the authority to impose curtailments and to determine on which basis to issue those curtailments to the deputy director, without, I might add, any direction on how to do that. You look at item C, it does list a few things that they can look at. That's discretionary. It says they may look at those things. It doesn't require them to. It doesn't require them to look at anything. It doesn't require them to tell anyone what to look at. We've seen the change sheet. That requires a summary. A summary of bad information is still bad information. There needs to be more meat in the regulation. But to make a long story short, we don't support the regulation because it simply goes too far. The way it's currently written, even if you strengthen the delegation parameters, it's still a violation of due process. And with all due respect to your legal counsel, while due process is somewhat flexible, it has some basic requirements. Notice and opportunity for a hearing is that requirement. The law does not go below that. There is some discussion as to whether that notice and opportunity for hearing has to come before or after you're curtailed. I think we would disagree on that point. But let's say we agree that it can come after. Your regulation doesn't provide that. Your regulation provides for absolutely no review. Your petition for reconsideration is completely discretionary. It does not offer a hearing. It offers the state board an opportunity to decide whether or not to give the water right holder a hearing. That is not due process. And we understand that your staff is trying to make this easier, but when you're talking about actions that could destroy businesses, actions that could kill permanent crops, it should not be easy. We don't believe that you should be looking to use crude tools to do something that critical. We don't think you should be looking to streamline the process when you're trying to take someone's livelihood away. Even if you have the authority and even if it needs to be done, it has to be done with all seriousness and all due process. Individual enforcement, as your staff said this morning, may be cumbersome, but when you're talking about something this serious, it is the law. The last thing I'll do is ask you, or your staff a question. And if I could have the slide that I brought, there's 2 slides. If you can just skip to the second.
That'd be great, just because we're over time. But
I
thank you.
apologize. But it's just a question, and it gets to the heart of everyone in this room trying to understand what is this process that we're looking at, okay? We have, staff showed a slide this morning that I believe was very, very misleading because it, unless I'm wrong, and if I'm wrong, please, Mr. Grober and council, correct me. My understanding of the difference between the current enforcement method and the emergency regulation method, the first step, you issue a curtailment, same methodology. You're not required to share that information. You just come up with it however you want and you issue it. The fines are exactly the same, except for the bold. There's a 500 a day regulation violation that's added, okay? There's also the opportunity to petition for reconsideration, totally discretionary, for that curtailment. The question I have is what happens after step 2? When you issue that cease and desist order, and if you can slide down, my understanding is under both instances, the diverter may request a hearing before the CDO is issued. This comes the real question of whether it's due process or not. Under the current law, at that hearing, the state board has to show that you do not have a right to divert the water under your water right. That's the due process hearing that exists today. My understanding is that under the emergency regulation, at that hearing, your staff needs to prove only that you violated the emergency regulation, only that you diverted when there was a curtailment order against you. They do not need to show or establish that you have no right to divert. Now, it didn't sound like that this morning. This morning it made it sound like you get your CDO hearing, you get your day in court, you get to prove that you can continue diverting. I don't think that's the case. And if we can ask staff to confirm that, then that is your difference in due process. Your emergency regulations grant no hearing whatsoever.
Answer?
I don't see anything fundamentally wrong with the flow chart that's put up there, except I don't agree with the contention that there's no due process whatsoever. An opportunity for a hearing is what due process generally requires, and it doesn't mean a full evidentiary hearing must be conducted in every instance or at any particular time. Opportunity for hearing is an opportunity for a hearing, and a petition for reconsideration is a hearing of the matters that are being addressed. And I mean, I think Mr. Laufer had addressed that issue already.
But the,
But it's discretionary?
but
Am I wrong, Mr. Laufer?
Actually, before, can I ask David a follow-up question? David, I want to focus on the 2 green boxes there. I think what I'm hearing is, it's not that a hearing will be held, but what is the purpose of that hearing? What is the fundamental determination that the board will be looking for at that hearing? And that there's a big difference between those 2 green boxes.
There is a difference, yes. Under Water Code Section 1831, the board can issue a cease and desist order, and so this is, the cease and desist order would happen after a hearing, not an opportunity for a hearing, but a hearing if one is requested. But the basis for a cease and desist order does include either the threat or the actual unauthorized diversion, which we've discussed before under Section 1052 of the Water Code, so that's an unauthorized diversion, or the SB 104, the drought legislation, added or violation of a regulation adopted under Section 1058.5. So I think the green boxes are accurate that one of the bases for a cease and desist order would be a violation of the regulation. So if the board wanted to issue a cease and desist order for a violation of the regulation, it could. I think
But
that
does a finding that the order has been violated includes the determination that the diverter had no right to pump that water?
No.
And that would only come in the discretionary petition for reconsideration earlier.
That question would still be addressed through the petition for reconsideration process, the due process that's being offered and was addressed up above on the flow chart as the new bolded language. The petition for reconsideration process is a due process that allows for vetting of the question of whether water is available to the diverter. So that has not gone away.
So you're saying that a discretionary hearing is a due process hearing?
I'm not sure what you mean by discretionary.
The State Board does not need to hold a petition for reconsideration hearing under the law. It's discretionary. They can say no.
The State Water Board doesn't have to hold an evidentiary hearing on a petition for reconsideration.
And of any kind of hearing at all.
I think we disagree about what a hearing constitutes for due process purposes. Maybe Michael can express that.
Maybe we can get the water code out.
This has helped me get closer to what it was you were saying the other day.
Yes.
So this is helpful.
So,
now.
David, Mr. Rose's analysis is correct in terms of the way that the process would work under the emergency regulations is essentially in the nomenclature of administrative law. When the original curtailment order goes out, if a diverter thought there was a problem either in the determination that water was unavailable or the relative priority, that individual would have to file a petition for reconsideration. And that's the process to challenge it. Yes, it is a discretionary hearing under the water code. The board, at all times when it's going through these types of processes, has to do a separate process under the Administrative Procedure Act, as well as under constitutional due process, to figure out whether or not that means a hearing. Now, the due process clause doesn't require a hearing, and a couple people have thrown that out. It requires notice and opportunity to be heard. That doesn't necessarily equate to an evidentiary hearing before the board. There are alternative vehicles, and in this particular, and that could be a paper hearing where, you know, it's all documentary submissions or otherwise, which is often the process that's used in a petition for reconsideration. It is a summary of the evidence that the party intends to rely upon. So if the individual exhausts through the petition for reconsideration process and essentially the order is final, obviously there's an opportunity then to seek review at court, and that's where some of these issues may be resolved in terms of the due process. But the board has the opportunity to enforce a valid order that was issued under the curtailment regulations. And that can occur at the conclusion. It could potentially occur in conjunction with the exhaustion of the remedies, although I realistically just don't see those kinds of scenarios playing out. Because there will be other enforcement tools available to the board at that point in time.
But wait, paint for me the picture of what's likely to. Let's say we issue, think about the curtailment orders that have already been issued for the post-14s.
Well, there
right?
haven't been any curtailment orders issued.
The order itself hasn't gone out, just the notices have gone
Correct.
out. All right. When would the orders go out?
Well, assuming that the board adopted the regulations, and it's certainly you would want to hear from your Division of Water Rights Enforcement staff, but my expectation is that in pretty short order for pre-14s or post-14s in certain watersheds, the board would, through the deputy director, would be issuing curtailment orders based on whatever regulations the board adopted.
And the orders would be individual as opposed to a watershed.
Correct.
Right. And in that case, we would get a petition for reconsideration would come in. And
Potentially
where would it
petitions for
go?
reconsideration.
And when would we be assigning a hearing officer? Would we be?
It would really depend in many respects on what were the issues raised in the petition for reconsideration. As you heard at the beginning of the day from I believe it was both Mr. Grover and Mr. Rose, if there were simple, errors that could readily be addressed, it would likely be resolved quickly and administratively. If there were fundamental clashes that required a resolution of factual issues through a hearing process, the board could potentially establish a hearing officer to hear those issues. Not all, and it's a test under the Administrative Procedure Act, not all clashes of fact require an actual hearing. It could be resolved on paper, and the board could issue an order that might uphold the curtailment order. It could issue an order modifying it, or, as noted by Ms. Leslie, the board could potentially exercise its discretion not to review. at which point in time there would be an opportunity for judicial review of the curtailment order.
Thank you very much.
Right,
And
thank you for
that's the
illuminating that.
circumstance that we're concerned about, that the board has the discretion to decide not to review. Thank you.
Thank you. That was extremely helpful.
That was helpful. Mr. Ruiz, followed by Jennifer Spalletta.
Good afternoon, Dean Reese, attorney for Woods Irrigation Company and also an attorney for Central and South Delta Water Agencies. My comments are very similar to Ms. Zalezi's, and I don't mean to stay on the same issue, but we just got to something. So at the point after 120 days, after the petition for reconsideration has been filed, there's a 30-day period where the board could take it up on its own motion, or a 90-day period in which a diverter has to wait to find out what's going to happen with the petition for reconsideration. During that time frame, a diverter who's been curtailed can't go to court. So you're sitting there waiting for your administrative remedies to be exhausted. It's now July 1st. This regulation, if it were adopted today after it goes to OAL, is going to be effective July 13th. It's 100 degrees outside. We're in the middle of the irrigation season. 120 days from now, what's going to happen? Where are we going to be when you're sitting before a court asking the court to find that there's a violation of due process? You're either going to have a dead orchard, or you're going to have someone who's diverted while facing ruinous financial penalties. I mean, it just doesn't make sense the way that it's set up. And we've talked a lot about a sliding scale, and due process is flexible, but due process has to be meaningful for it to matter. And the way this is set up, it simply isn't. So I don't know how you fix that except not to adopt the regulation, or to build in something that says a petition for reconsideration has to be heard and decided within 14 days or 21 days, something that's meaningful, that doesn't have a diverter sitting around waiting while, you know, over this critical period of time. So I'd like you to consider that. In addition to that constitutional due process issue, there's also a significant issue with regard to an improper delegation of authority to the deputy director. The way this legislation is set up, or this regulation is set up, it vests the full discretion of the deputy director to figure out what to do with respect to curtailment. These are issues that are, as we've sat here today for almost all day, we still don't really understand how this would be done. It's new territory. It's clearly policy making. It's fundamental policy making. It's not something that can be abdicated to the agency. It's something that needs to come from the legislature, and it didn't. And as a result of that, you have an improper delegation on top of your fundamental due process issue. So I would urge you to seriously consider that as you move forward. Also, there was some talk earlier about, well, you know, maybe there's some process short of curtailment, some way to go about this, and there was some discussion about, well, if we're going to communicate better, I don't know how that actually would work, but, you know, one thing that would be helpful as we sit here